your skills, your expertise, your knowledge, and the value that you're going to hand to the Supreme Court. We particularly want to hear your vision.
Yes.
You should tell us who you are beyond what you have done.
Okay.
Yes.
Thank you, Honorable CJ and the commissioners. My name is Dalmas Omondi Ohungo. I am a husband and a father. I am a judge of the Environment and Land Court, having been appointed in the year 2016. My journey in the legal profession started 28 years ago in 1998 when I was admitted to the bar. Upon appointment as a judge, I was posted to Nakuru ELC, where I served until September 2021, mid-September, when I was transferred to Kakamega. I served there until mid-January last year, 2025, and then I was transferred to Nyamira County, where I currently serve. I'll just give you a snippet of my service and professional life so far, which I think will then answer to the question of what I present. I'll first begin with my professional capabilities and delivery. When I was serving in Nakuru, by the time I left Nakuru, the performance report of 2020-2021 reflected Nakuru as the overall best court in ELC. I don't need to go into details because of time. Subsequently, I went to Kakamega, and the performance reports will show that I have a very high merit productivity. This is reflects cases actually heard and determined by a judge on the basis of judgment and rulings written. Both the performance report of 2022, 2023, and 2023, 2024. I will not also go into too much detail at this point. I had a very high, leading actually, case clearance and merit productivity. While I served in Kakamega, the Honorable Chief Justice appointed me the presiding judge of that station from March 2023, and I served in that capacity until I left. I think this is significant, one, because the Honorable CJ bestowed trust and faith in me, but above all, it's important to note that at that time, I was not necessarily the senior most judge in the station, but we worked very well. We were 5 judges in the station, I as an ELC judge, 3 High Court judges, and 1 ELRC judge. And we displayed collegiality with a very good working relationship. While working in Kakamega, I had the occasion to chair the ELC judges serving in the region, that is Bungoma, Busia, including Kakamega, and we were able to deliver on a very important project under my leadership, which is we developed a manual for self-represented litigants, a major milestone in access to justice and people-centered justice. The whole idea behind the manual is to help litigants who do not have the benefit of an advocate to know how to navigate the court processes. Also, one thing I would mention is that throughout my entire professional life, I have exhibited leadership qualities. I was from the onset, from 2001, I was a member of the Council of Mombasa Law Society, the oldest bar association in the country. and the second largest bar, and remained in leadership in that bar association in various capacities, rising to become the vice chairman of that bar association. Again, in my life, I have both private and public life, professional life. I've exhibited the highest degree of discipline, professionalism, and integrity. In the 10 years that, about 10 years that I've been a judge, this commission has not had, not even once, to write to me asking me to respond on any allegation touching on integrity. That speaks to my qualities as an individual and as a judge. So these are the qualities, Honorable Commissioners, that I present before you, and if the Commissioners find merit in them, this is what I present. I intend to take to the service in the Court of Appeal. Thank you.
Thank you. Commissioner Mwansa, for reading the next set of questions.
Thank you, Chief Justice. Judge, good afternoon again.
Good afternoon, Commissioner.
I want to cite for you a quote by a famous American poet,
Yes.
Maya Angelou.
Yes.
She says that courage
Yes.
is the most important of all the virtues, because without it, you can't practice any other virtue consistently.
Yes.
Now, one of the virtues that interests me is the virtue of judicial courage.
Yes.
And perhaps, Judge, can you explain to us what are the key aspects of this virtue?
Thank you very much, Commissioner. Courage is indeed an important virtue, and in the context of service as a judge or a judicial officer, the aspects of courage is that a judge has to be able to make the decisions that the case before him, the facts and the law and the reliefs sought call for, without looking into other issues on the side. So the ability to make the decision that the case before the judge calls for.
Okay, can you demonstrate to us one? I mean, you've made perhaps hundreds or so forth decisions.
Yes.
One that stands out in terms of an expression of judicial courage. So
yes. Thank you, Commissioner. Yes, I've made many decisions. I think one case in which perhaps I can cite is I sat on a bench. This was an expanded bench matter, concerned the construction of the famous Itare Dam. And at that point there was I think a lot of clamor around the project, and we had the case with my colleagues in the bench. I was not alone, and we made a decision that spoke to the courage of the occasion and what was required of us, independently of the clamor around the particular case. I would cite that, Honorable Commissioner.
Thank you. Judge, perhaps I want to ask you about arbitration. You've had occasion, I'm sure, to read or interact with the Arbitration Act.
Yes.
And it's one of the live issues that ordinarily would land in your desk as a possible Court of Appeal judge.
Yes.
Now, you've read the decision in Newton?
Yes, I have.
And what's your understanding about that decision?
You're referring to the Supreme Court
Yes,
one?
yes.
Yes. My understanding of that decision is that the Supreme Court elaborated on or highlighted and explained the very, very unique circumstances in which a party who has gone before the court challenging an arbitral award has gone before the High Court. When dissatisfied with the decision of the High Court, can then appeal to the Court of Appeal. And the Supreme Court really circumscribed those circumstances into, in fact...
And how does a party who's aggrieved by a decision
Yes.
of the High Court,
Yes.
in terms of enforcement or setting aside,
Yes.
travel to the Court of Appeal?
Well, they would travel ordinarily in the normal manner, file a notice of appeal within the requisite period, and thereafter file the record of appeal together with the memorandum within 60 days.
Yes. They do not have to seek for leave first before they file.
To go to the Court of Appeal in this respect.
Yes. From a reading of Newton.
I do not think that they need leave. I think they will meet the questions as to whether they fit within the parameters of Newton once they find themselves before the court.
Okay. Actually, what the Supreme Court said in that matter is that for purposes of sieving such matters, the Court of Appeal has to first test whether that is one is a case that can be admitted, and that has to be tested through leave.
Okay, then I would need to refresh. Yes.
Now, if you read section 35 of the Arbitration Act, it provides for very limited, as I said, I mean, it provides for grounds upon which you can set aside an arbitral award. Number one, that the party to the arbitration was under some incapacity, that the agreement is not valid under the law which subjected the parties to it. That's the law of Kenya. The party making the application was not given a proper notice of appointment, and the arbitration deals with a dispute not contemplated by the contract. That gives that right of arbitration. Now, there's a very interesting statement that was made by the Supreme Court. I want to read it and then ask a question or two about it. Now, paragraph 76 of the Newton decision says as follows, that reading each of the above provisions, alleged breaches of the Constitution cannot be properly introduced by way of an application to set aside an arbitral award. I repeat?
Yes.
Okay.
Yes.
Reading each of the above provisions, that is now the provision under section 35. Alleged breaches of the Constitution cannot be properly introduced by way of an application to set aside an arbitral award. Breaches of the Constitution are properly governed by Article 165.3 and 258 of the Constitution, and cannot be, by litigation ingenuity, be introduced for adjudication by the High Court to the by adjudication by the High Court by way of invocation of Section 35. Okay. So let me first just make a statement that my understanding of this, probably you're the judge, and our understanding might be the same or not. It says that you can only attack an award based on Section 35 and under the subset or the grounds that are provided for. However, the Supreme Court says that breaches of the Constitution are properly governed by 165.3 and 258. So, from a reading of this statement,
Yes.
can one say that it is possible to attack an arbitral award under 165(3) and 258 of the Constitution? And if such is the case, how would a party approach that? Because already you are limited under 35.
Yes. My immediate reaction, Honorable Commissioner, would be that it wouldn't be possible to attack an arbitral award under either section 165 subsection 3.
Yes.
Is it? Yeah, article. I'm
yes,
sorry.
Yes.
Article 165 sub-article 3.
Yes.
Or article 258.
Sorry. Just say that again.
My reaction is that it wouldn't be possible to attack an arbitral award under Article 165, sub-article 3. I think that was the question.
Yes.
Or even Article 258.
Yes.
For the reason that the arbitration process is a consensual process which is meant to be insulated from judicial interference. So it's always important to remember that just like the Supreme Court stated in Newton, the window for interference has to be very small. So Section 35 lists already the occasions
yes.
when one can, and the grounds through which one can attack an arbitral award. On the other hand, these other sections or articles of the Constitution really deal with the issues of enforcing the Constitution, which is, I would say, a public law, constitutional law matter, as opposed to a contractual arbitral dispute situation.
Okay, let me just follow up on that.
Yes.
Suppose the complaint,
Yes.
or the grievance by one of the parties to an arbitration is centered on Article 25.
Yes. Yes.
25C.
Yes.
That fundamental freedoms shall not be limited to C, the right to a fair trial.
Yes.
And then perhaps again it is centered on Article 50.
Yes.
Article 50, I think, on the right to a fair trial also. I think
Yes.
the rights of
Fair hearing.
Fair hearing.
Yes.
So it is based on that.
Yes.
So you go before an arbitrator,
Yes.
and you are denied the right to cross-examine
Yes.
as a party.
Yes.
And that cross-examination is material on, if you look at the award, on whether on how an arbitrator arrives at a decision.
Yes.
Would then a party to such a matter who's aggrieved come to the High Court under its powers, unlimited in criminal and civil, 165(3) and 258, to challenge it based on that?
Yes.
Because it is not one of the grounds that are provided for under 35.
Yes. That's an interesting one, Commissioner. The right of cross-examination is at the core of a right to a fair hearing.
Yes.
And access to justice.
Yes.
In the perhaps rare event where an arbitrator who knows his trade and the rules refuses to allow cross-examination, I perhaps would say that perhaps they may fit within what the Supreme Court said, that there's such an injustice that maybe those are not the words of the Supreme Court, but cries to the heavens for relief.
Actually, an injustice that drives the party from the seat.
Yes, so yes, it's rare and likely, but if it ever happened, perhaps there would be room.
Okay.
Yes.
All right. Thank you, CJ. That is all.
Yes, Judge, welcome once again.
Thank you.
And you have been in the ELC court for 10 or so years now.
Yes.
And I'm sure one of the issues you've been grappling with, maybe at a personal level as a court or even as a country, has been the issue of adverse possession.
Yes.
Adverse possession. And there has been serious debate on whether the magistracy has jurisdiction to deal with adverse possession claims. What
Yes.
position do you take, Judge?
Yes, thank you, Commissioner. Adverse possession is one of those things that we have had a serious debate on within the ELC, whether magistrates have jurisdiction. And I had taken the position that magistrates have jurisdiction to handle adverse possession claims. I know there are my colleagues in the ELC who took a different position, and I took that position because I looked at the basis through which people move the court on claims of adverse possession, which is section 38 of the Limitation of Actions Act, and that section talks of the High Court. The Limitation of Actions Act is a statute that was enacted in 1967, if I'm not wrong, way before the current constitution. And so I read that act, that provision, which mentioned the High Court as against, I think, Schedule 6 of the Constitution. There is, I think, Section 7, which says that all legislation that was in force as at the promulgation date must be read with the necessary adaptations. And I took the view that one of the adaptations required is to take into account that, one, the Limitation of Actions Act does not talk of ELC because it predated ELC. And then I also took into account that the ELC Act gives the ELC jurisdiction in matters land, of course, in addition to Article 162. But then the ELC Act also gives magistrates jurisdiction in ELC matters. If I'm not wrong, that is Section 26. The ELC Act, again, is a statute which came after the Constitution. And then the Magistrates Courts Act also gives magistrates who are gazetted by the Honorable CJ jurisdiction to hear land matters. And in my reading of the Constitution, I did not see anything that excluded magistrates. In fact, I thought that the Act, read in context, gave magistrates jurisdiction. I must say, however, that my position has now been overruled by the Court of Appeal. Yes, I wrote a decision, but there was no appeal on my decision. There was some other appeal, yes. And the Court of Appeal in Sugawara, yes, held that magistrates have no jurisdiction. And I think there's also a second decision, I think Atieno and Luango, which was in 2025. Sugawara was in 2024. So from stare decisis point of view, the decision of the Court of Appeal now rules, and the position is that magistrates have no jurisdiction. All these other things can only be for academicians to talk about until the position changes.
Okay, thank you for that clarification, especially the
Yes.
fact that the issue is now firmly settled by
Yes.
the appellate court.
Thank you.
Thank you. Now, still on land matters, let me take you to land ownership
Yes.
prior to 2010
Yes.
by non-citizens,
Yes.
vis-a-vis land ownership post-2010 by non-citizens. Before, non-citizens could hold property on freehold basis.
Yes.
And upon promulgation, the Constitution has it that if you're a non-citizen, then you can only hold on the basis of a leasehold.
Yes.
Now, a scenario arises and the matter comes before you that a non-citizen who had freehold interest in a very prime parcel of land in Nairobi has received a request from the lands department that he has to surrender his freehold title so that it can be turned into a leasehold under the current constitution.
Yes.
Then he comes to court and he says, no, this is unconstitutional because I had my rights which were protected by the Constitution before 2010. That was also a constitution.
Yes.
And it protected my freehold rights.
Yes.
Now, if you are to take away these rights, you have to award me compensation and damages.
Yes.
What will you, I mean, how will you deal with that?
Well, on the face of it, it sounds like an unjust situation on the face of it, but we have to look at it against the provision of the Constitution itself. The Constitution itself proclaims and declares that land holding by non-citizens must be on leasehold. So I think it would be difficult for the litigant to persuade the court that the Constitution has been unfair to him, so to speak, because this is a constitutional provision. Perhaps he may want assurances from the land registrar that he'll get a 99-year lease from the date that the land registrar approaches him and asks him to go for conversion. And when the lease expires, I think there shouldn't be any reason why a renewal should not be given on terms that are just to the land owner. And 99 years is not too short. If the landowner leaves and gets a renewal, I don't think he would outlive the renewals. So, well, it may sound unjust, but the Supreme Law says so, and I think there were strategic national reasons that led to that. So I wouldn't think there's discrimination.
Okay, thank you so much, Judge. You're right. The long and short of it is that you cannot challenge the Constitution. The Constitution cannot be unconstitutional.
Yes.
Thank you very much,
Thank
and I wish you the very best.
Thank you, Commissioner.
Yes, good afternoon, Judge.
Good afternoon.
I'm sure in your career you have dealt with fugitive offenders or fugitives.
I've largely been in, of course, in ELC. I have dealt with civil matters, and so I must confess I have not in my career dealt with that, but I would still welcome your question, Honorable Commissioner.
Okay, but as you go to the Court of Appeal, you know you'll have to deal with many other subjects other than what you're doing now?
Yes, yes.
Do you know the difference between extradition, surrender, and reciprocal backing of warrants?
That is extradition.
Surrender. And the third one is reciprocal backing of warrants with regard to fugitives.
Extradition is a situation where the government of one state receives a request from another state seeking that a particular individual be transferred to the requesting state so as to answer to criminal charges in the requesting state. Surrender, I probably hazard a guess on this, would be perhaps a situation where one state or the individual being sought, being cognizant of the fact that he is required to answer to charges, avails himself to the authorities of the country that needs him to answer to charges. And the last one was
reciprocal backing of warrants.
That one, I must confess, Honorable AG, I would need to refresh on that.
You are not very far off with surrender, because the only difference would be the procedure.
Yes.
Because extradition goes through a long procedure. Now the question is,
yes,
the Supreme Court of Kenya recently settled the law on extradition proceedings in Kenya.
yes.
Are you aware of this case, and which case is it? And what was the legal question presented before the Supreme Court for determination?
Honorable Commissioner, I must say that I would need to refresh on the case in which the Supreme Court dealt with this matter.
Do you know of any legislation or conventions that govern extradition in Kenya? Or treaties?
I was going to mention the foreign judgment reciprocal treatment or enforcement, but I think that deals with something else. I'm afraid I would have to refresh.
No, it's okay. It's a special area, but it is good because you're going to the Court of Appeal.
Yes.
And the more we open our borders, globalization, AI, cyber, the scene of crime is now moving to the cyber world, which is very fluid.
Yes.
It's good to be abreast of the international requirements
yes.
in criminal matters. So finally,
yes.
how should an appellate court balance environmental protection obligations with the state constitutional mandate to promote economic development and infrastructure expansion?
With the state's constitutional obligation to
promote economic development and infrastructure expansion. You want me
yes.
to give you an example?
Well, would be.
Do you remember when the expressway was being built?
Yes.
Oh, so you can now
yes.
try.
Yes, thank you, Honorable AG. The duty to protect the environment is a duty that is cast on all of us. As a matter of fact, the Constitution itself at Article 42 grants every citizen the right to a clean and healthy environment. So when we have to balance between economic development and the protection of the environment, then the court would be called upon to consider and apply environmental principles. Some of those include the precautionary principle. Sometimes there is not enough evidence to really support for example, the petitioner or the complainant may not be able to marshal and avail all the evidence to show that this particular project will be a threat to the environment. So in some of those occasions, the court is entitled to deploy the precautionary principle to balance this or to deal with this situation. At the end of the day, environmental conservation and economic development are all valid interests. So it's a delicate balancing act, and sometimes we have to remember that economic development will not make any much sense when the lakes rise and swallow the expressways that we have, built. So it's a delicate balance, but we have to listen to the environment, because ultimately it will make us to sit and listen. And we've seen this happening around the world and in our own country. So the economic argument sounds sometimes very powerful, but in the long term, the environment prevails.
So how would you apply the value of sustainable development in balancing the rights?
Yes, so sustainable development essentially means that as we do these projects, we have to consider how the project will interact with the environment in the long term. So in some projects, Honorable AG, you mentioned the expressway, and I think in that project there were some provisions which were made for wildlife to go under. So those are sustainability interventions that one can do so that a project coexists with the environment.
So it is then true that the Constitution itself provides some principles, values and principles of governance that can help us to balance.
Exactly, and sustainable development is one of them.
Thank you.
Thank you, Honorable Chief Justice. Judge, judges are part and parcel of this society.
Yes.
And I think it is imperative that we at all times are conscious of what is happening in society, and more so as it relates to the indigent.
Yes.
There was a time, some time back, when there was an offense in the Penal Code, and the offense was that of being a rogue and a vagabond.
Yes.
And because of civil society making so much noise that you're criminalizing poverty, that was subsequently done away with.
Yes.
But basically the offense of being a rogue and a vagabond,
Yes.
when you think about it, is there mens rea?
Well, the accused in this case, I would say, has no deliberate intention to be, a homeless person. I don't think so. So there's no mens rea.
There is no mens rea.
Yes.
So these are offenses that are actually referred to as status offenses.
Yes.
It's because of you being poor, and that is why the law criminalizes it.
Yes.
Apart from the offense of being a rogue and a vagabond, which, as I've said, it was removed from the Penal Code, can you think of other offenses that fall under this classification that speak of the status of the person?
None comes to mind immediately, Honorable Judge, Commissioner. None comes to mind immediately. I would have to look at the penal code. I would have to refresh on that.
Not necessarily in the Penal Code per se,
Yes.
but even in the county bylaws, other statutes, for instance, the Public Health Act. Should I give you another one?
Yes, Honorable
Hawking?
Commissioner. Pardon? Hawking.
Hawking.
Well, I think that's true in the sense that if I was the person hawking and I had the opportunity to work in a better situation, I wouldn't hawk. So I have no choice in the matter, and it
So
goes
many
to my
a time
status.
we see askaris from the city county
Yes,
having running battles in the city of Nairobi.
yes,
So that again is an offense that touches on the status of the
Yes.
person.
yes.
Now, a survey was done by the, actually an audit report on criminal justice system, and this was done under the auspices of National Council on the Administration of Justice, and they actually found that 70% of the crime in our country are these petty offenses.
Yes.
And I would like you to listen to this statement, and then thereafter we can have a discussion.
Yes.
In Kenya, the probability that a petty offender of a humble means will lose their liberty at any point in the criminal justice system is extremely high.
Yes.
Thinking of arrests and thinking of the subsequent trial in a court, do you think that that is correct or not correct?
I agree with the statement. The likelihood of a petty offender, losing their liberty is very high, and in this case, I think we are talking about liberty from the perspective of once they take plea.
Before we get to plea.
Yes.
Yes.
Just by virtue of arrest. I think it's high because
How are they arrested?
pardon?
How are they arrested usually?
Well, usually sometimes this is done by way of what we sometimes call soups. Sometimes in situations.
So a soup
Yes.
on a Friday evening?
Yes.
Yes.
Yes. So if I think the likelihood of Commissioner, you wanted me to continue with that or to give another?
Just feel free. It's a discussion.
Yes. So the likelihood of this soup being done on a Friday evening, it will most likely, if you compare it to a dragnet cast by a fisherman in the sea, it will most likely catch the people who are vulnerable, who probably is out on the street. Sometimes some of them are moving from one piece of work to another. So the likelihood of injustice, losing liberty, is higher. Judge Ohungo probably will be in his house at that time. So if you cannot, there's some sense of injustice in that situation because the vulnerable will most likely be.
So they have been
line.
arrested in a soup. Monday
Yes.
morning, they're appearing in court.
Yes.
Take us from that process of appearance in court.
Yes.
What is most likely to happen?
Yes.
Because you've indicated that you're in agreement with the statement that I read to you.
Yes. So when the person is presented in court on Monday morning, one, they are not likely to have the benefit of legal representation due to economic circumstances, and therefore they lose the opportunity to pursue certain possibilities or remedies. Number two, once they take plea, they are entitled to bail or bond by law, but again, for the reasons of economic circumstances, they may not find themselves
So
posting.
before we go any further,
Yes,
let's assume that in the soup,
yes,
500 persons were netted.
yes.
How will that plea be recorded?
Maybe I would benefit from a clarification, Honorable Commissioner. How would the plea be recorded?
Yes.
I'm not sure if I understand the question in the
There are-
sense of the plea taking one by one.
Yeah,
Or,
that's what I want you to tell us, because now they have been taken to court, they have appeared before a magistrate.
Yes,
They are 500 in number.
yes,
The magistrate needs to process them.
yes.
How will this be done?
Yes, so there would be obviously a challenge and a possible injustice in that, because each of them would need to respond to the charges by indicating whether they agree or disagree. And I would imagine, technically, this may be either one matter or split into several matters. But either way, humanly speaking, by the time the magistrate deals with the litigants brought in as a result of this soup, they may find themselves, they are dealt with later in the day, they are unable to, even if they had the financial capacity, they...
So it's more likely that the plea will be taken en masse.
Yes.
And it's also very likely that even those who are not guilty will plead guilty.
Yes, because again, sometimes lack of information, yes, or knowledge of rights.
So in your own view, given these challenges that we are facing, what recommendations would you then want to make to the justice sector to see that we are fair to the indigent in our society?
One thing I would say is that there would be some offences that perhaps would need to be relooked by virtue of their impact on the indigent. But then at the same time, there would be obviously offences that you cannot do away with, and so the issue comes to law enforcement. I would approach it the same way that we have approached minor traffic offences. Law enforcement has to be not an opportunity to harass the citizens, and not everybody needs to be hauled to court, and definitely persons who are arrested are entitled to their rights under the Constitution. So law enforcement sometimes, even when dealing with indigents, may look harsh, and I think that would need to change.
Are you aware, finally, are you aware of what the Constitution provides when it comes to dealing with petty offenders?
Yes, in terms of...
In particular, Article 49(2).
Yes.
What does it provide?
Well, in terms of if they are convicted, they shouldn't be sentenced to a prison term as much as they should be. They would be entitled to a fine in lieu.
That's very correct. Thank you. That's all from me.
Thank you, Honorable Commissioner.
Yes, good afternoon.
Good afternoon, Judge.
So I'm going to ask a question which has some subsections, if I may call it that.
Yes.
What is a structural interdict and what is its purpose? And what steps does a court take when issuing one?
Yes. Honorable Commissioner, structural interdicts are orders which a court makes upon determining a matter, and which then are a follow-up to the enforcement of the relief granted, and this is common in constitutional litigation, also in environmental litigation. Even if it did come in as constitutional, it can happen. The court supervises the enforcement of its orders, so to speak. In the ordinary cases, the winning party executes. But here there would be an aspect in which the court supervises. And so the purpose of structural interdicts is to ensure that the judgment and the orders of the court are actually effected, because for example, speaking about environmental litigation, the order of the court could be that maybe some action be taken regarding waste disposal, and therefore it's important that for reasons of environmental requirements, right to a clean and healthy environment, the court may want to be sure that that has actually been done. So the purpose is to ensure. And the steps that the court would need to take, perhaps the court may want to mention the matter after some time to be sure that the orders have been implemented. I think that comes to mind immediately.
Thank you, Judge. Actually, I was hoping
Yes.
that you would draw us to your sample writings.
Yes.
You have submitted
Yes.
the matter of Martin Osano
Yes.
Rabera,
Yes.
in which you found
Yes.
there was a violation
Yes.
of an environmental right,
Yes.
and you did issue a structural interdict.
Yes.
But I wanted to point out that you did not attach
Yes.
the following proceedings of you
Yes.
following up
I see.
on the order. I'm just saying,
Yes.
because when I was reading through,
Yes.
I had to go and find out what it is that you did. And
Yes.
you actually did, you followed it up.
Yes, I followed it
But
up.
you should have submitted it as a sample writing as well.
Yes.
It's just useful. It's always good to see a judge
Yes.
who has used this remedy.
Yes.
Yes.
Yes, I didn't talk about it because I thought another commissioner was going to ask me about sample writings.
Oh, are you going
Yes.
to? Sorry,
so,
Commissioner.
but I did, and I actually wrote a ruling.
Yes.
And there was I was frustrated in that situation. And sometimes as a judge, you can't go in there and force people to do beyond speaking through your decisions. And this involved a garbage dump in a major town. And so I could only speak through my decisions.
Thank you. So let me ask my second brief question. The Supreme Court, in the matters of Mutava, Moya, and Chitembwe, have set out the standard of proof in removal proceedings of a judge. Are you able to recall what that standard of proof is? Or what the burden of proof is in removal proceedings of judges?
I would have to refresh on these particular decisions, but I would think that depending on the nature of allegations made against a judge, if there are allegations which essentially revolve around civil issues, there would have to be proof on a balance of probabilities. If, however, Judge Ohungo is accused of things that border on criminal conduct, I would elevate it to proof slightly above balance of probabilities, but not to the extent of the criminal standard.
Okay.
Yes.
You are guessing, but you are correct.
Thank you.
Thank you.
Thank you. Yes.
Thank you, Chair. Good afternoon once again, Judge.
Thank you. Good afternoon, Commissioner.
Okay. Do you want some time off to drink water, or you are okay?
I am okay. Yes, I drank water as I was waiting.
Glad to hear that.
Yes.
Okay, so you submitted sample writings or judgment and rulings
Yes.
touching on environmental rights, adverse possession, cancellation of illegally acquired title, and the likes. So your writings demonstrate clear issue identification, structured and reasoned application of law and fact, and consistent analytical depth. Your decision reflects purposive and formalistic approach, balancing statutory, constitutional, and procedural requirements. So you properly cite precedent and statutory provision, and your language is professional. So we must commend you for that, for the good job well done, including the one that Judge Njoki has mentioned on enforcement on environmental rights.
Thank you.
But I did take note that the very recent sample writing you submitted is dated 2022.
Yes.
Why? Have you not been doing any work from that time, or you felt as though those ones that you have worked on from 2022 to date are not, they've not created novel doctrines?
No, I have been doing a lot of work. Actually, I'm one judge who churns out many decisions. But sometimes when these opportunities to appear before the commission arise, they catch you in the middle of many things, and you probably can easily omit things that you would have otherwise included. So there was really no reason, but I have judgments as recent as
yesterday.
Just before I went on leave. No, I went on leave in December. Yes, but it's just a coincidence.
Okay, good
Yes.
to note. You write well, Judge. So the Environment and Land Court is required under the Constitution and statute to be more inquisitorial. Yet we are in an adversarial legal tradition. Environmental disputes often involve negative externalities. The public policy people call it negative externalities, where the cost of development is not just borne by one individual, but communities, ecosystem, and future generations, who at times don't come to court to explain their interest in a particular matter.
Yes.
So how would you as a judge in an adversarial legal system be able to identify these issues and address them, because at times they're not even pleaded,
Yes.
without undermining judicial neutrality, due process, and parties' autonomy?
Yes, yeah, thank you, Commissioner, for the question. You are right that these externalities are often, schemed over, and sometimes litigants don't mention them. The parties, both sides, you'd expect sometimes that one side goes out of the way to address this. A judge is supposed to be neutral and give parties an opportunity to be heard. And so, if for whatever reason I thought that there's an aspect that needs to be addressed, I would pick it out, I think during pre-trials, and then I would give both sides an opportunity to address the issue. I think that is the only fair way. In environmental litigation, the costs can be immense, and sometimes the litigant who has moved the court is is a hapless citizen who is faced with a big multinational, and there would be a challenge, for example, for an ordinary litigant to come up with all the computations and the computer projections as to what will happen to the sea levels and the lake levels in the next 30 years. So it's a delicate balance, but the court can, if, for example, it's a constitutional litigation, the court can admit amicus brief, which would shed light on some of these aspects. So the idea is just to hear both sides, give an opportunity for both sides to address the court, but I realize there are challenges, especially if one of the parties is less privileged economically, and this may happen many times.
Okay, so would it be proper then for your court, before you go to the Court of Appeal?
Yes.
Is it in order for your court then to direct a government agency to come and submit a report? Because now within, when you engage a government agency, for example, responsible for the water levels, would that be in order without any party asking? And can a court on its own motion request a party to join in as an amicus?
As much as possible, the court has to be neutral, and so hopefully you hope that the parties who need to address the issue come before the court and seek to join, whether as amicus or if it's in constitutional litigation as interested parties. I would be a bit shy to just say that so and so you should be in this matter as an amicus, because then the life of a judge is perilous, and I'm likely to be asked by some other citizen, why did you pick on so and so and not this other one? And I may very well not have a good reason as to why I excluded some other expert. Okay. So it better comes through the initiative of the parties, or some person comes from out there seeking to join as an amicus, and my work is just to deal with the parties who actually come before me or present themselves.
So about then the very nature of the court, the inquisitorial nature of this court, of the
Yes.
specialized court.
Yes.
So where does that place you, if you say you will be bound by what comes before you?
Well, there's for example, room to deal with these issues without overexposing oneself to claims of bias. Sometimes, for example, when you get reports from government officers responsible for certain aspects, that is neutral to a large extent. So there's a limited scope, but I must say limited.
It's limited, but at least it's there.
Yes, there is room, especially when dealing with government officers.
Okay. Lastly, you mentioned you are PJ while you are in Kakamega.
Yes.
And there is this saying that goes, culture eats strategy for breakfast.
Yes.
There's been a lot of extensive judicial transformation since 2010, but there is a public perception of view that justice delivery is still yet to get there. So in your view, what type of judicial culture within the institution should be changed for Kenyans to feel the actual impact of the transformation?
I would say, Commissioner, that the perception that justice is not done is a serious one. And so I think judges like myself and judicial officers have, through our conduct, through what we present before the public, have to conduct ourselves in such a way that the public on first impression, at least have a chance or feel that they have a chance of justice coming from us. And because what you raise is a question of perception. So at the end of the day,
perception, it could be true. You
it
are
could be
PJ
true.
judge, yes.
Yes. So we have to, as they say, like Caesar's wife, be beyond reproach. It's a high calling, but by virtue of having taken oath of office, there are many things we have to give up. Sometimes I think as judges or judicial officers, we can avoid some of the misconceptions just by the choices we make, the company we keep, the places we go to. And as simple things as, for example, if you must go to the supermarket, you choose at what point you probably will not be misunderstood. You may want to shop early in the morning and not at rush hour. So it's the choices we make as individual judges and judicial officers, because it's a question of perception. So if I am seen, in some Nyama Choma place with the other members of the public, there may be nothing wrong which has happened, but people may misunderstand me.
Okay.
So I may ask for the Nyama Choma to be brought home.
Thank you. I was looking for what needs to be done inside the judiciary. But I'm satisfied with that response.
Thank you, Honourable Commissioner.
Thank you, Chair.
Thank you, Chair. Good evening, Judge. It's
Yes.
still afternoon. Good afternoon.
Good afternoon, Commissioner.
I'm just beginning to wonder whether any Kenyan listening to this interview would want to be a judge.
Well, it's not easy. It's not easy, but we need doctors, so people have to be sacrificed and face gory situations, so people have to sacrifice to be judges.
Okay, that's true. So I'm looking at your performance report from DISPOP. I don't know if you were given a copy.
I got a very brief, I don't know whether what the Commission gets, I should also get it, but I got a report which was, I thought it was too brief, but I didn't have time to pursue.
I equally have a brief one. The one we get at the Commission is actually mined from the data that you have on the CTS.
Yes.
So I presume it must be the same.
Yes.
I hear you saying that you're a hard worker, you churn a lot of judgments, and I've also known you since our practice years in Mombasa to be a hard worker.
Yes.
And even the reports that we have from your referees that have gone through, and even the public, presumably those that appear before you, is that you're a hard worker. But I'm looking at this report, I'm not sure what the problem would be. How long have you been in Nyamira?
I've been in Nyamira since mid-January, January 15th of 2025.
So it's about a year?
Just about a year, yes.
So I have a report here indicating, and I'm looking at judgments. You are alone at the station, so there's no question of comparison on workload.
Yes.
Everything that is done in that station has been done by you. So the only comparison I can look at is confirm whether you have met your performance targets. And what I have from Nyamira is that in a combination of 24-25 and 25-26 up to September 2025. We are going as per financial years.
24, I would fit in from mid-January last year. Yes.
And that's why I have a report covering 24-25 financial year and 25-26 financial year, but up to September.
Yes.
Because these were prepared shortly after the application, not up to date as in today.
Yes.
So according to the report, the judgments you have from Nyamira are only 4.
Yes.
1 from 24-25 and 3 from 25-26, which I'm assuming now start from July 25 to September 25.
Yes.
So I don't know what the problem may be.
Well, the Commissioner, what happens when you are on transfer to a new station? You carry work from the other station. So when I went to Nyamira, I had files from Kakamega, I think about 70 of them, So if you look at Nyamira and then place it alongside Kakamega, you would get a truer picture of my output. Then the other thing also, when you go to a new station, it takes a while before you are able to bring matters to maturity for judgment. So my explanation is that I have, during that period, delivered quite a number of Kakamega judgments, and the record can show that. But in the meantime also, the matters that I took over from my colleague, the ones which were mature for judgment, my colleague went to write the judgments. So now I am in the process of making them ready, hearing. So perhaps if I was to remain in Nyamira in another 1 year, probably my true output would show, because the matters would then be ripe for judgment.
Okay, what you are saying is somewhat borne by the report.
Yes.
Because I see indeed you had quite a number in the same period from Kakamega, totaling I think about 56 judgments alone.
Yes.
I have not included the rulings where the case was closed, so I think it's borne out.
Yes.
Okay, so something else I wanted to ask, Order 11 of the CPR.
Yes.
It was basically introduced for purposes of case management to expedite conclusion of cases. In your view, do you think that purpose or that objective has been achieved?
Partly yes, but partly no. The Order 11 as initially conceived was the judges and judicial officers were to play a role, but there was also the expectation that there would be I think case managers who would then help to sift through things as so that by the time the matter goes before the judge or JO, a lot of these things have been dealt with. And the absence of case managers has impacted the original good that would have drawn from Order 11. So we have not fully realized the benefits of Order 11. But on the other hand, there's a big benefit in the sense that by the time we confirm matters for hearing, by then parties have had an opportunity to see what the other person's case is, what documents they rely on, and parties acting hopefully in good faith are sometimes able to see that, look, this is a matter that we can settle. So it has helped, but there are challenges, which is largely due to, I think, capacity issues.
Okay. Yes, we've not had case managers, but I like what you say about in good faith.
Yes.
There are opportunities in Order 11, under Order 11 rather,
yes,
to if parties were to act in good faith, to be able to narrow down issues so that the trial process is even shortened.
Yes.
And that is one of the reasons why we have not really reaped the benefit of that order. Yes. But I want to also hear from you. How do you carry out your own pre-trials? Or is it done by the Deputy Registrar?
In Kakamega, I would do my own pre-trials. In Nyamira, I found the system different. The DR would mention matters, and I decided not to. Sometimes it's not good to disrupt systems immediately you arrive. That's so true. I let that for the time being. And so what I would do in, I don't know, I think you had not asked the question. That is where I was headed,
yes. So you can go ahead and answer the question. In Kakamega, how would you go about it?
So in Kakamega, what I would do is that every matter, as soon as they say the plaintiff comes to the registry, files the matter, they would leave with a mention date. And so I would mention the matter, give it, say, a month or 2 months, so that appearances enter DTC. So I would then mention the matter. If they've not served summons, I would want to know, why is it that you've not served summons? Sometimes the litigant wants to evict, but they've not served summons. So eviction, you should be readily served. So once we go through the issues of service, and parties have filed their pleadings, at some point in the course of the mentions, I would want the parties to, of course, confirm that they now have all their documents in place. We can then narrow down the issues that are for determination in the matter. And ultimately, I would give a hearing date. So I would take care to ensure that the mentions are not too many, so that I take the view that a litigant who has moved the court does so when they are ready. So I would expect them to be a little bit quick-paced, but within the rules as to compliance with the steps that are required.
Okay. And isn't that when you also explore the possibility of using ADR? I've not heard you mention that.
Yes, yes.
And also deal with interlocutory applications?
Yes, yes, certainly. For example, in matters before the ELC, a lot of them have connotations of succession, and there's always room for parties to talk. So during the mentions, I look at the file, I sometimes realize that the dispute is between father and a son. So there's a lot of room for them to go to mediation and try to resolve the dispute there.
Okay. You've given us one example of an order you can make at the end of the entire process under Order 11. That is to certify the matter ready for hearing.
Yes.
And to give it a hearing date.
Yes.
There are other orders that you could also make.
Yes.
Which are these other orders? The possible orders under Order 11.
Yes. So under Order 11, it's possible also for the court, upon looking at the parties' status of compliance and taking steps. For example, if there is non-compliance, if the plaintiff doesn't serve summons, so the matter has been in court for a while, the court can, an order of striking out is a possibility at that stage for non-compliance with court processes. The court can, depending on what submissions the parties bring, the court can make an order for further discovery, yes, among others.
Okay, I'll take that, but there are some specific orders provided under Order 11 that maybe you can look at.
Yes.
Okay, thank you, Judge, and I wish you well.
Thank you.
Thank you, Honorable Chair, and good afternoon, Judge.
Good afternoon, Commissioner.
Let me take you to a softer area.
Yes.
How would you balance the constitutional imperative for expeditious justice with limited judicial and administrative resources? Expeditious justice with limited resources.
Yes. So it's a requirement under Article 159 that justice should be rendered without unreasonable delay. But at the end of the day, the balancing between expedition and substantive justice, I believe that was the question. The court has to lean more towards doing justice as much as possible. So all these things have to be examined within the context of doing justice to the case before the court. Sometimes even failure to do things on time can be a manifestation of injustice. In short, what I'm saying is that the call to do justice is slightly at a higher level. So expedition is required, but justice has to be done. So, yes.
Do you believe case backlog is primarily a resource problem or it's a management problem? Is it the issue of resources or it's the issue of not being organized?
I think in the present context, case management or case backlog is to a large extent a resource problem. I would say 100%, to a large extent a resource problem, because if you don't have enough judges, as now in the Court of Appeal, there's only so much the judges there can do. But I agree that with better case management, we can dent the backlog. So largely a resource problem, but there is room for improvement through better case management. Yes.
So how would your colleagues describe your professional integrity?
Colleagues, judges?
Yeah, and the people you interact with,
yes,
the advocates,
yes,
the stakeholders.
They would describe me as a person of integrity, and I think they would not doubt my integrity. This is primarily because of how I conduct myself, and I'm responding to this. I cannot respond to it because I have been asked. So, without sounding to be not being humble, but largely colleagues and the public will judge from how one conducts himself. So they would describe me as a person of high integrity. In my opening remarks, I said that this commission has not had to ask me to explain an integrity situation, in the sense that, these allegations fly around a lot nowadays, but I thank God that the way I have conducted myself, I have not had or fallen short on these requirements of integrity. Yes.
Very well. Actually, that resonates with the feedback that we
Yes.
have from the stakeholders and the public. They all agree that you're a person of high integrity. And I commend you for that.
Thank you.
Now, lastly, what are some of the key elements of an independent exercise of judicial authority, and how do you apply it?
So some of the key elements of independent exercise of judicial authority would be that a judge determines cases before him or her without influence from any quarters, be it the public or the state. So the judge's decisions are his own decisions and not influenced by any, I would say, pressure or other things from out there. And a big aspect of this is we all take oaths of office when we start these things, and there's a lot that is contained in that oath of office. And from time to time, I think judges and judicial officers need to just look at their oath of office, and they will draw a lot from it.
Thank you, Judge. I wish you all the best.
Thank you.
Thank you, Honorable CJ. Judge, I have a few questions for you.
Yes.
Have you ever been in a situation where you received a report or allegations of a member of your team receiving bribes or soliciting for bribes from the public?
No, I haven't actually received a report of any member of my team receiving a bribe or soliciting. I haven't.
Okay.
Yes.
If one was reported to you or it was brought to your attention
Yes.
that one was soliciting for bribes, what would you do?
I would want to find out what exactly has happened, bearing in mind that nowadays these allegations are sometimes common. So the first step is that I should know my team, and so there are certain allegations which, if made against member B of the team, I would probably, I'm not saying that I would prejudge, but everybody needs to know the people they work with. And so beyond the perception, because even me as a judge, I may have a perception about members of my team, then I should inquire to find out what is the basis of this allegation. Is there an element of truth in it? And beyond just my own judgment as to whether there's an element of truth in it, there would of course then be issues of law enforcement on these integrity concerns. Internally, there would also be other steps that would need to be taken.
I'm looking for the internal ones.
Yes, so internally, in this case, assuming I'm a presiding judge, I would, of course, call the member of the team concerned and have a conversation with them, not alone, maybe with the presence of the head of station, and try to get to their version of the events. This would also need to be discussed. There is an integrity committees we have nowadays, which should also address this. And also we have the LMT, which also would have an input on this. And then the issues can be escalated within, quite independent from other processes, law enforcement processes.
Okay. Please tell us any practical measures you've put in place for the staff who work directly under your leadership to ensure that they remain motivated and engaged, and to ensure that their performance is at the best levels.
So the staff who work under me, first of all, it is my duty as the person who they report to recognize accomplishment. So when they do well, I recognize that, and as much as possible beyond my personal recognition, I also ensure that their accomplishments are recognized at the station level, so that because sometimes that probably would count a lot, and in any case we may not have any other thing we can give beyond recognition. So just the opportunity to mention a staff in front of others and say that, or during a staff meeting and say this staff has worked well and has accomplished the following, I think that is a big motivation to them. But also I let them know clearly what I expect from them in terms of the right thing to do, because again, as a team leader, I have to sort of set targets and lead by example in terms of the right things that they need to do.
Okay. Thank you, and I wish you well.
Thank you, Commissioner.
Good afternoon again, Judge.
Good afternoon, Commissioner.
Hope you are not too tired.
No, I am still ready to go.
Okay.
Yes.
Fine. I don't have a lot of questions for you, but
yes,
maybe one or two.
Yes.
Why are international partnerships important for institutional development and capacity building?
Well, I answer you.
Yeah, proceed. If you are satisfied, you.
Yes, international partnerships are important for institutional development. One, because international partnerships give institutions an opportunity to view themselves, their capacities against other institutions out there, and so we are then able to see how are other people doing things out there. We are challenged to improve, and if we are doing things well, we also have occasion to thank our teams locally and find ways of doing things even better. In the context also of our economy, international partnerships sometimes result on maybe resources that would help us to bridge some of the shortcomings that we have. So they are very important.
Can you give an example? Can you give an example of how international cooperation has improved outcomes in your professional experience?
Yes, Commissioner, thank you. I can perhaps talk about, I know that by the time I was joining the judiciary, we had this program, I think JPIP, and it has done a lot in infrastructure development and facilities. Some of the courtrooms in which we sit were only came to be because of that partnership. So that's one example I can think of, a practical way in which international partnerships have been impactful in the work that I do as a judge and in the judiciary as a whole.
Thank you. Thank you, CJ.
Thank you very much, Judge. I think we have really engaged you.
Thank you.
And thank you, Commissioners. I just want to wrap it up by you, Judge, telling us how you would, if you are successful, 3 or 4 things you would do to improve the performance in the Court of Appeal. You realize that we have a huge backlog of cases there. What would you do to help in reduction of that backlog?
Thank you, Honorable Chief Justice. If I get a chance to serve in the Court of Appeal, I would make some recommendations which I think can help. One of the things that I think we have to insist on is that litigants should only move the court when they are ready. And if they are not ready to move, to proceed to the next level, they would have to think twice about engaging the court processes. So perhaps I would recommend that in the Court of Appeal rules, there would be a requirement that when you file first we reduce the period within which you file your record of appeal, because we have overcome the historical challenges of getting proceedings, etc. So I would reduce it to 30 days. And then on top of that, I would say that...
I think the problem is not even the litigants who are late in filing, is that they have filed, but the appeals are there, they are not being determined.
Okay. So, yes, so beyond the overcoming the challenge, the part of the litigants, So there would then be the issue of the actual hearing and determination. There's the issue of applications. I think all applications at the entry point should, as much as possible, be a single judge matter, unless it is an
one is to make the application under 5.2b.
Yes,
a single judge
judge matter.
Next,
the other one would be what I wanted to talk about was mostly on the filing side, because I think that also has an impact, because if people file appeals and they keep telling us, I don't have the proceedings. In fact, one of the things I did when I was especially in Kakamega, I would tell them, file the record without the proceedings, and let me have the burden of ensuring that the proceedings are here. And I would call the court admin of Butali or wherever, and the proceedings would. So in this day and age,
I think that can work for the criminal appeals.
Yes.
For the criminal appeals.
Yes.
That is one. Expedite the proceedings, because they are now online. They are now online, and they are transcribed.
Yes.
Yes. So the use of technology.
Yes.
Yes.
And I also wanted to add on the issue of the use of technology. We can use technology to facilitate the pre-hearing processes of appeals. One of the things that I have recommended to the ICT team is that in this day and age, when people file pleadings, they should file on the CTS a PDF which is interactive. The system can interrogate it and read it, as opposed to a block PDF that the system is unable to read. So
I think all that technology is in the Court of Appeal. If you have checked, that is the court.
Yes.
That is completely paperless.
Yes.
Yeah.
Yes. So I think those are the ones that come to mind, Honorable CJ.
Yes, Judge Shishare.
Yes.
Thank you, Honorable CJ. What about asking the courts below the Court of Appeal to undertake their work in a professional manner, in a diligent manner, and not influenced by any other extraneous factors, so that we have fewer appeals filed in the Court of Appeal? What do you think of that?
My take, Judge and Commissioner, is that my experience is that there'll always be appeals. Even when you think you have the best judgment, because litigants are entitled to test the system within the permission of the law. Maybe they may not go to the Supreme Court on some things because the law stops them. But as long as there's a right of appeal, I think there'll always be appeals, because litigants are a little bit more informed. Their advisors want to do advocacy, and it is their right to do advocacy. So I wouldn't count. Well, we should do our job well, and it's important because
because every time they come, if the case was properly done in the lower court, then they will keep bouncing, hitting the wall all the time.
Yes.
And they'll stop coming on, because
hopefully in good faith, if they act in good faith, that may. But it's important that when somebody gets a judgment from Judge Ohungo, they read it and they ask themselves, is it really worth appealing against this? If I appeal, will I lose the appeal and maybe incur costs? So our judgments have to be a disincentive to appeals. But beyond that,
that's what the judge was saying.
Yes.
Any other way we can reduce backlog in the Court of Appeal?
Honorable CJ, I think the Court of Appeal needs more hands, and I hope the Commission gives us those hands.
Okay.
Yes.
More hands, and I hope they can also explore how to use AI.
Yes, and ADR, which I think the Court of Appeal is also using, yes.
Very well. I think this brings us to the end of the interview. It's been quite robust. We thank you and thank also the commissioners. But before you leave, we always give a candidate an opportunity also to engage with us. So it's your time now to engage us in whichever way you like.
Yes, mine is to thank the commissioners for giving me this opportunity to appear before you and to have this conversation. Throughout the process, I have felt treated well as a candidate, and I can only pray that at the end of this process, the Commission will give the nation the judges of appeal that the nation so much requires. And I think I've just been here for some few hours today. You've been here throughout the process. So I think I must express gratitude for the work that you are doing in the demanding circumstances, in this recruitment and generally in the administration of justice. Thank you, Honorable CJ.
Thank you, and I wish you all the best. We will get in touch with you when we complete the process. We have now released you, and we wish you all the best. Our regards to the people of Nyamira.
Thank you very much, Honorable CJ.
Okay.
Thank you. I can carry these ones.